In a very short statement, for HR record keeping, I would say basically two things. Document, 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 and then don't get rid of anything until the statute of limitations has expired. So I come to the table today with a heavy litigation background from the perspective of defending employers, defending municipalities, defending supervisors in litigation that has arisen out of the employment context. So I dealt with records in a variety of capacities, but I want to try to, the best I can, focus more on today just the day in and the day out things you need to do record keeping wise, but with the ultimate goal that it could end up in litigation. You could end up in some sort of dispute. If it's not a litigation and a lawsuit, it may be arbitration or some informal process that your city or town may have. So that's kind of the perspective that I want to go over today. I know you've all probably heard of the Open Records Act. You may have to deal with the Open Records Act on a regular basis. I'm curious to know, I would like to know what the makeup of you are here. Am I dealing with city managers? Do I have mostly city clerk treasurers in here? Kind of give me some feedback. What are you guys mostly? Okay. Well, so you probably are very familiar with the Open Records Act. I'm guessing you're probably the person designated within your city or town as the person to respond to Open Records Act requests. Is that a fair assessment for most of you? Well, so it's rather academic, but the obvious reason for the Open Records Act, the public policy behind it's just what it says here. It's to facilitate the public's right of access to reviewing governmental records. And that ranges from whether it's in personnel records to billing records to payment records to invoices. Generally, just about anything you do, I mean, this is a broad generalization, but most records, most documents, most emails, most tangible things that a city or a town uses or utilizes or creates or generates are going to be subject to the Open Records Act. There are certain things with individual employees that are not subject to the Open Records Act, or said another way, an individual's date of birth, an individual's social security number is not subject to the Open Records Act. It's not something you have to give out in response to an Open Records Act request. In fact, the Open Records Act requires you as the employer to protect the date of birth, social security number, and the home address of current and former employees. It probably doesn't come up very often in the context of an Open Records Act request where you're asked to provide, for example, Sally Smith's date of birth or her social security number or her address. That usually only comes up in the context of litigation. But you may be asked to provide a list of all employees and their payroll or their salaries, or a list of all employees and their disciplinary history, or catalogs of information. And it's just important that you, if you're going to provide that information, you've got to redact those things I just listed. So security number, date of birth, their home address. Under the Open Records Act, it's Title 51, Section 24A.7 that sets out what is or is not an open record under the Open Records Act. You're looking at it right here. So a public body may keep personnel records that relate to an internal personnel investigation, or that relate to examination and selection material for employment, or that relate to hiring, employment, promotion, demotion, discipline, or resignation. So this top section is what you as an employer can choose to keep confidential under the Open Records Act. Now, as an employer, I mean, you can give them anything you want. There's nothing that in the Open Records Act that says you cannot give something other than date of birth, social security, and address. But these are things that you can withhold if you receive an Open Records Act request. Of course, relate to, up here on number 1 where it says relate to, that's a really gray area. And so when you get an Open Records Act request that may ask for a specific document, like for example, let's say there's a personnel investigation or an internal investigation of Sally Smith in the city clerk's office. And this investigation was conducted by somebody outside the city who prepared a report that's 35 pages long. Part of those 35 pages consists of the author of the report did interviews of employees A, B, C, and D. Here's what employees A, B, C, and D told me. Here are the documents and records I reviewed in support of or regarding the claims at issue. Here are my findings as the author of the report. And sometimes they may have done audio recorded interviews of the employees that they interviewed. And sometimes those might be transcribed into a transcript. Sometimes they might just be put on a CD and attached to the report. And usually in these reports, you may have a conclusion where recommendations are made, or where options are given. Here are the options that you have. You may have a portion of this report that refutes the allegations that have been made against the person you're investigating. So that entire report, is it an open record? Well, I mean, it relates to an internal personnel investigation. It may relate to discipline or resignation. It may relate to promotion or demotion, depending on the substance of what is being discussed in there. My recommendation is when I do these, or when I did these when I was in private practice and when I advise municipal employers today, if you get a personnel investigation report, an internal report that outlines the things I just described, I do not consider that. Seldom is there a hard and fast rule, but generally speaking, that is not going to be subject to the Open Records Act. I wouldn't keep an internal investigation report in the individual's personnel file. I would keep it separate and apart from the personnel file. What if this investigative report on Sally Smith results in the city manager or the city administrator or the mayor issuing discipline? For example, Sally Smith is suspended from work for 3 days without pay. And he prepares that, the mayor or the city manager, city administrator prepares a memo, a document of whatever kind, even if it's an email that says, Sally Smith, you are suspended from work for 3 days without pay based on the allegations that you XYZ, fill in the blank. That document itself is a document that is putting this Sally Smith on a suspension. And as such, under the Open Records Act, it is an open record. So under the Open Records Act, these are the things that are subject to the Open Records Act and are considered an open record. And if you do get a request for an open record, then you have to provide these things. And remember a minute ago where I mentioned where it said items that relate to personnel investigations, and it's really gray. My advice usually is let's make it as gray as possible and only give what you absolutely have to give. So in my example where Sally Smith was suspended for 3 days for XYZ violation, and she got a memo from the mayor or the city manager, whomever, telling her that single document itself, telling her she's suspended for 3 days, is subject to the Open Records Act. Whether you keep it in the personnel file or not, it's subject to the Open Records Act. Somebody requested Sally Smith's personnel file. John Doe out in the public may request her personnel file. He's not entitled to the personnel file, but documents within it he would be entitled to. That would be a document that you would have to disclose. These other examples seem obvious. An employment application of somebody who becomes a public official. So if you hire somebody who comes to work for the city, that person's application is subject to an open records request, provided you redact or black out Social Security number, date of birth, address. I'm trying to think of some examples. Maybe a city gets a request for something. That's usually the most common. I mean, that in my experience, that's typically the most common request that you get is just somebody out in the public making a request for the personnel files of somebody in particular, or and I say somebody out in the public, it could be another employee. You could have employee Sally Jones makes an open record request to look at the personnel file of employee Sally Smith. Only Sally Smith, as the employee of the city or town, she has a right to access and review her personnel file while she's an employee of the city. But Sally Jones doesn't have a right to look at her personnel file, generally speaking. She has a right to make an Open Records Act request and obtain documents from it. Questions I often get are the complaints made by, whether it's a complaint made by a citizen walking down the street or a coworker or an employee, are complaints made about or against employees subject to the Open Records Act, or do they have to be produced under the Open Records Act? And my answer generally is going to be no. They don't fall in this exception here, which tells you the things that have to be produced. So when you go to look at the Open Records Act, there's a specific section on personnel records, and this is what it tells you has to be produced. The city can always choose to provide anything else. But when it comes to personnel records, these are the things that relate to personnel records that you have to give in response to an Open Records Act request. Under the Open Records Act, the courts have interpreted what time frame. How long do you have to respond to an Open Records Act request? Well, the courts have just interpreted it. The statute, it says reasonable and prompt access. So you get a request today, it may take you a week to get it together. a week's fine. If it's going to take you 6 months to respond to it, that's probably a little bit too long. So when you get an Open Records Act request, those are the key terms: reasonable and prompt access. I'm skipping around here. If your city or town doesn't have a written procedure on how to submit an Open Records Act request, it should have one, and that should include, it should be posted generally at your city clerk's office. It should say, here's the person at the city where requests are to be made. Here's the time frame each day that we are open for these requests, 8 to 5, 8 to 4, whatever it is, Monday through Friday. Here's what it costs for an Open Records Act request. And then you should have one person designated in the city. Generally speaking, you should have a person designated to handle those Open Records Act requests. I know the last OML conference, y'all didn't have this last year, I believe. So I believe the last OML conference would have been, in 2019. So since then, there have been two real important, or I consider them important, cases addressing Open Records Act and as it relates to personnel records that have come out since the last OML conference. One is out of Custer County. Let me pull them up when they were issued. One was from the city of Owasso. One was from Custer County. So let's see. The city of Owasso, that was, in April of 2020, that was the city of Owasso case. And I don't know, we may have somebody from the city of Owasso here. But that was what I consider a very important, a big case regarding the Open Records Act and HR-related records. In that case, the city had hired an outside attorney to do an internal investigation of the city manager. Complaints had been made that the city manager had acted unethically or unprofessionally or possibly illegally or unlawfully in some things that he had done or had instructed others to do. City hires an outside investigator, conducts an investigation, prepares a report that was something like 200-something pages long. Now, that 200-something pages long included attachments. The actual report prepared by the attorney, I think, was 23 pages, something like that. But the entirety of the report submitted to the city council was almost 200 pages long. The city negotiated a separation agreement with the city manager, which included him retiring, and he was paid a severance fee pursuant to whatever his contractual arrangement was, and it was a substantial severance payment. A council member submitted an Open Records Act request for the internal investigative report, this 200-page report, and it was a years-long litigation. The city resisted it, but ultimately, like I said, in April of 2020, the Oklahoma Supreme Court the Court of Civil Appeals ruled that internal investigative report, that 200-page report, was subject to the Open Records Act and had to be produced. A couple of the things that the court focused on in that case was that the issue was a city manager who was an important administrative policy-making individual was the subject of the investigation. The reason for the Open Records Act request being submitted was why was the city manager allowed to resign and be paid a large severance fee or a severance payment when in his contract he could have been terminated for cause, and the for cause could have been the alleged improper behavior, improper instructions that he gave to some of his people at the city, things that he had done wrong at the city that possibly could have resulted in criminal charges. Now, he wasn't criminally charged with anything, but there was a grand jury investigation into some of his activities and some of the things he had instructed people to do. Basically, one of the things he had instructed people to do was a city council member had been arrested or had been stopped for a DUI. Within a day or so of this happening, he told somebody at the police department, delete the video footage of it delete the video footage of this council member being arrested or stopped and then taken home. He wasn't arrested or charged with it. That was one of the complaints, is that the city manager had instructed somebody at the police department to delete this video. And it turned out that wasn't actually a criminal act, but that was one of the reasons, one of the subjects that he was being investigated for. So the purpose of the Open Records Act and that request was to determine this guy allegedly committed malfeasance, wrongdoing, potentially criminal behavior, and he had a contract with the city that that would have allowed him to have been terminated, not received a severance payment. Yet the city did pay him a severance payment, a substantial severance payment. So we want to see this investigative report, and ultimately the city had to turn it over. So when I said a moment ago that I don't consider internal personal investigations to be subject to the Open Records Act, I would really have to qualify that or put an asterisk on that statement. It's going to be a case-by-case analysis. It's going to determine, it's going to depend upon, I think in certain instances, what's the reason or the rationale for the internal investigation being done, and what's the reason or the rationale as to why the Open Records Act request is being made. So those are just things to be very, very acutely aware of when you're dealing with, if you are dealing with an Open Records Act request that is asking for matters that relate to internal personnel investigations. One other very recent and this is another Court of Civil Appeals case. This is a case that came down in April of 21 this year, and it seems quite obvious to me, but surprisingly there was a lot of litigation over it. This involved the Custer County Sheriff's Office, and an Open Records Act request was made to the Custer County Sheriff's Office from a group out of state. I think they were in, Wisconsin or Iowa. I'm not sure, somewhere in that part of the country, not from here. And the request was for a variety of documents to be submitted electronically by the Sheriff's Office to the requestor. And the Sheriff's Office compiled the documents that was to be provided and told the requestor, here are our hours. We're open Monday through Friday, 9 to 4, whatever it is. And here's the person you talk to, and here's what the fee is. These records are available for you to get. And in other words, I'm not going to send them to you by email. And he also said, I'm not going to fax them to you. All that the Open Records Act requires me to do is make them available to you here in my office. And so that's what the lawsuit resulted in was, I've asked for them by email. It doesn't cost them anymore. And if you think about it, email, we all use email all the time nowadays. Really, for me at least, and I imagine for most of you, sending things by email is much easier and quicker and faster. But in this case, the sheriff took the position, I don't have to do it by email. The Open Records Act doesn't require that I do it by email, and so I'm not going to send you these documents by email. And the court upheld that, said the Open Records Act doesn't require it, so that's just a little tidbit for you. You don't have to produce things by email. You can. Again, everything under the Open Records Act, for the most part, is discretionary. A city can always establish policies and procedures or practices that do allow for production of records by email, that do produce personnel investigations. You can always, you can broaden what you do within your city from what the statute requires, but that's what the court held in that case as it relates to email requests. Surprisingly, as easy and as it is to transmit things by email, you don't have to do it. I suspect the legislature will somehow fix that and make it easier for the public to receive documents that way, but that's not been done yet, at least. Okay, I told you an employee has a right to review his or her own personnel file while they're an employee. So when they're no longer an employee, that's not what the statute requires. It's just while they're an employee. So a personnel file, most cities and towns that I've dealt with for 25 years have the city clerk's personnel file, or maybe the treasurer holds the official city personnel file, the file that has the application, maybe, the routine employment documents that you have to fill out, the W-9, the bank statements, ACH draft, insurance selection forms, those routine documents that most employers have usually are maintained in the city's official personnel file that the city clerk holds. But oftentimes, the department head that employee is working in has his or her own personnel file. Sometimes there's the city official personnel file, and then there's just the other personnel file that maintains other documents, whether it's leave requests or memos that relate to an employee's job performance that may not go in the official personnel file. There's no definition in state statutes under the Open Records Act as to what it comprises a personnel file. But because an employee has a right while he or she is an employee to access his or her own personnel file, I think it's a good practice that in terms of the personnel file that you maintain on your employees, that is the city's or the town's official personnel file, have just those documents that I just described. The application for employment, all the insurance selection forms, the receipt of a handbook, receipt of policies and procedures, receipt of their job description if you have that. Those routine documents that you would find in every single employee's personnel file in the ideal world. You would find those same documents in every individual employee's personnel file. Then I would also put in an employee's official personnel file those documents that we just discussed that are subject to the Open Records Act, that if you were requested to provide it, you would have to provide it, which would be if you have actual formal discipline that is issued to an employee, I would put that document that reflects the discipline. Not the 200-page investigative report or the 5 or 10 memos that you have from various levels in the chain of command or various department heads or various employees when you're investigating the complaint or taking whatever investigatory actions you're taking to look into whether this employee should be disciplined. Just the final document that results in discipline, I'd keep that in the personnel file. If you have a document that at some point after a year, if you've been disciplined, you've got a written reprimand, it can come out of your file. Once that year, if you've got a policy that says that, once that year passes, I presume if you're going to have, most cities that have a policy that says that, there's some steps the employee has to take. So if you have a written reprimand within 1 year and you've had no disciplinary problems since that 1 year, once that 1 year passes, you can petition the city to remove it from your personnel file. And if they do that, and you've got a policy that says that, and they do that, you remove it from the personnel file, remove it from the personnel file. So it's no longer in that individual's personnel file because he or she may have a right, may come ask you to look at it, and they want to make sure that you, the city or the town, have done your job in removing that personnel document. But don't get rid of that personnel document, that document that showed that they were going to be suspended or that they had been disciplined or demoted or whatever it is. If that's a personnel document that relates to any kind of disciplinary action of any kind, no matter how stiff or how minor, if you remove it from the personnel file, do not just chunk it. Don't get rid of it. We'll talk about how long to keep those things here in a minute. But the short answer as to why not to get rid of those things is because you may need it for later on down the road if litigation results. So this is a handy little chart. I brought printouts of this PowerPoint. If anybody wants it, y'all are welcome to take it, or I'm happy to talk with you individually. Coming to the point of litigation, these personnel documents that I'm saying, you don't have to keep them in the personnel file, in the official personnel file, but you need to have a file on that employee that relates to these any kind of disciplinary matters of any kind, because you may end up in litigation. Whether it's litigation over, let's just say, using a hypothetical example, there's a memo that was placed in Sally Smith's file because an individual complained that she was abusive and hostile in the workplace. An investigation was done. That investigation was done via the HR person at your city, talking to people at the city and talking to the people who were involved and coming to the conclusion that, yeah, Sally Smith was abusive and hostile and she said some things she shouldn't have said, but she's a good employee otherwise. We haven't had disciplinary problems with her before. And maybe, it's not that big a deal in the big scheme of things. We're not going to terminate her. We're not even going to demote her, but we're going to give her a written reprimand. And in a year, you've got a policy that allows in a year that can come out of her file. So that comes out of her file. Then 6 months after that, you get another complaint of the same or similar nature against her, or maybe involving another employee, a totally different department, but another employee. And you go through that same process again. At some point, you may end up in litigation over the people who have been the victims of Sally Smith or any other employees' supposed or alleged hostile or abusive treatment in the workplace. And you, the city, may be sued for allowing this hostile or abusive supervisor or employee to be in the workplace. Then you, the city, would need to defend, well, here are the actions that we took. We investigated the complaint against Sally Smith. We conducted an investigation. Here are the people we interviewed. Here's what we concluded. And we gave her a written reprimand. But a year passed, and we have a policy that says we are allowed, the employee is allowed to petition the city to remove that discipline from their file. And we did remove it from the file. but you want to be able to show you took action, you were proactive in response to the complaint. So that's why you want to keep these documents that you may be removing from the personnel file. When you hear the phrase, I mean, a lot of people sometimes tell me when they hear, oh, they took it out of the personnel file. There's nothing illegal or unlawful about doing that. There are reasons that you would do that. And I think it's a good practice as a general rule to have a policy that allows an employee, after, let's say, a year, to ask the city to remove certain levels of discipline. If it's just a written reprimand for showing up to work 5 times late in the span of 10 days, and that's a no-no, and you get a written reprimand for that, and you have no other disciplinary problems, you've got a policy that allows in a year they can request the city to remove that. I think that's a good policy to have. A practice like that allows for the consideration of removing things that are disciplinary in nature, but they're not significant, they're not major. That's a good practice. That's a good policy to have for purposes of morale, at least. So this chart tells you, kind of goes through some of the things. State statutes, this statute right here, Title 11, Section 22-131, that is a state statute that sets out specifically records that a municipality has to keep and for how long they have to keep them. They're not just personnel records. There are a variety of records that the cities have to keep or municipalities have to keep. But in particular, since this topic is on HR-related records, if you have an employee handbook or employee policies and procedures under Oklahoma law, you've got to keep those at least 5 years, unless your council has or your town board has set a policy or by resolution or and otherwise acted a policy that requires it to be longer. So you have, let's say we have policies and procedures today, and we amend them in a year. And then we amend them again in 2 years. So in the span of 4 years, we've gotten 3 versions of the employee handbook. Well, you need to keep that first version and the second version, well, you need to keep them all, at least 5 years past the point that they are no longer in effect under state law. Unless your city or town has said we're going to keep them longer. Then the other thing on here, the other qualifier is, let's say you keep them 5 years, but you're in litigation, and litigation can last for 2, 4, 5, 6, 7 years. Litigation can go on. So before you were to get rid of an old box of employee handbooks sitting in storage or personnel policies and procedures, anything that's related to employee handbooks or policies and procedures, I would just not get rid of them any sooner than, you can't under Oklahoma law sooner than 5 years, but make sure you have no litigation that's ongoing. If you have any litigation, any employment-related litigation, whether it's an actual lawsuit, whether a tort claim has been submitted, whether there's an arbitration going on out of the fire department or out of the police department, if you have anything going on like that, I would not get rid of any policies and procedures or employee handbooks until it's completely concluded. Because it's very, very likely and possible that those prior policies and procedures will come up. Same rationale with payroll records. Everybody has different kind of payroll records, but state law requires you to keep them 5 years once the employee is gone. So I'll leave on December 31st, 2001. You got to keep them at least through December 31st, 2006. Unless there's litigation involving me, then you got to keep them longer than that. Sometimes I get asked, there may be an official personnel file at the city, and supervisor files on individuals, or you may have an investigation file on Sally Smith, and that's separate and apart from her official personnel file. All of these things that we've just talked about, I guess, except for training certificates. I haven't mentioned that, but that might be something that you would find in the official personnel file. All those documents under state law, like I mentioned, Oklahoma state law, you need to keep those for 5 years following the ending of employment. If you don't have, this is kind of off topic, if you don't have, it surprises me that today to find cities that don't receive, or towns that don't have a receipt document that employees have received, a policy and procedure manual or the employee handbook. If you don't have that, you really should have that. You should implement that. And you can go to OMAG's webpage. There are sample HR policies, sample HR related documents on the OMAG webpage. You can call us anytime, and we'll walk you through how to find it on the webpage, or we can send you it, email it to you real quickly. That's something that you should, if you don't have it, I would encourage you to implement that practice for obvious reasons. You've got an employee who claims, I didn't know that this was my chain of command, or I didn't know that this was my job description, or I didn't know I was supposed to report this. And if you've given them the policies and procedures and it's all outlined there and they've signed for receipt for it, then you can show that, yeah, you did know, or you should have known because we've given you these and you've signed for receipt for it. These, again, are just some of from the Oklahoma statutes that talk about how long you have to keep applications for people who are not hired. That's probably something, it wouldn't surprise me if many of you don't keep those things, but you do have to keep applications of people who aren't hired, at least for 3 years from the time that they apply till they're plus 3 years, then you don't need them. We talked about policies. Again, at the OMAG webpage, we've got sample policies, I think, that address almost everything that you see up here. And these are things that, like I mentioned, you need to keep for 5 years. Litigation holds, what are those? If you don't know what that is, exactly what it says, you may get a letter from an attorney representing an individual employee that says, I represent employee so-and-so, and I demand that you preserve all documents regarding his or her employment. Some people call it a records retention request, a litigation hold, anything that puts you on notice, whether it's a letter, a tort claim is something that would put you on notice. You might not get a letter from an attorney, you may get a tort claim from an employee, or whether they're pro se, meaning they're representing themselves, or whether it's through an attorney. You may get an EEOC charge. EEOC is the Equal Employment Opportunity Commission. There are certain laws that if an employee, or current or former employee, is going to complain about, they have to go to the EEOC before they can file a lawsuit. If you get an EEOC charge, or a notice of tort claim, or a letter from a lawyer, or a letter from an individual threatening a lawsuit, those are the 4 things that you might get that would fall into this category of a litigation hold. And once the city is on notice that a lawsuit could result, and those are the ways that you're on notice: EEOC charge, a tort claim, a letter from a lawyer, or just a letter from anybody threatening a lawsuit. You have an obligation under the law to preserve all documents that relate to that employee. And it's significant. It's a significant penalty if you do not do that. Significant penalty in the legal system, that is. So you have an employee who submits a tort claim and goes to the EEOC, and there's a lawyer that writes a letter that says, I'm representing so-and-so, we think she was wrongfully terminated, we demand you preserve all evidence regarding her employment. Lawsuit is filed, you're going through the process of a lawsuit, and the city didn't keep her personnel file, or the city didn't keep the personnel file of the individual who complained about the employee. So let's say we've got Sally Smith complains about Sally Jones, and Sally Jones ultimately gets terminated. And Sally Jones' attorney, Sally Jones goes to the EEOC, she submits a notice of tort claim, a lawyer writes to the city and says, I'm representing her, we're contemplating litigation, preserve all records. And you go through litigation, and it comes up that, well, Sally Smith is who complained about Sally Jones. It was her complaint. And so the city at that point should have already taken steps to preserve not only Sally Smith's personnel file, but also Sally Jones' personnel file, and any documents that may relate to the matter at hand, the written complaint that was submitted by Sally Smith, the memo that was prepared by the department head or the supervisor, or the statements that were collected by the individuals. I mean, this all seems obvious that these are things that you would need to keep, but you would be surprised how often people don't think, oh, that's something that we might need in a lawsuit. So I would encourage you, anytime you get an EEOC charge or a tort claim or a threat of litigation, first let OMAG know, but also let your city attorney know, and try to think outside the box as best you can. Is there any document that we have that would relate to this person's employment with us that could in any way relate to the issue that they're complaining about in the EEOC charge, or in the tort claim, or in the letter that's threatening litigation? Because what happens in the lawsuit, if you don't keep those things, and the case proceeds, in the worst case scenario, goes to a jury trial, or a trial in front of a judge, that employee is going to ask for a finding by the judge that you, the city, were required to keep this information. You didn't keep this information, and the only reason you didn't keep it is because it was hurtful to you. And as a result, the judge instructs the jury, tells the jury, they had documents, the city had documents relating to this claim at hand. The city was required by law to keep them. The city did not keep them, so you, jury, you are allowed to infer that the city's evidence that they didn't keep was hurtful to the city. So I'm going to say that again. If you don't keep something that you're required to keep, A jury could be told the city was told to keep these things, they didn't keep these things, and therefore you can infer that these records showed something bad. And that is a death sentence in a lawsuit. So when I said a moment ago that a significant penalty can result, that's what I'm referring to. If a jury were to ever be told, you had evidence and you destroyed it, that just is really bad. So that's one of the reasons we're having this conversation today, as to why we keep documents in HR. These are just some little food for thoughts. We go electronic. I know at OMAG we are essentially a paperless office. At my office, my law firm, before I came to OMAG, for the last many years, we've been a paperless office. Everything's either done electronically or it's converted to an electronic document. And some of this seems obvious, but if you can scan in color, save things in color, that's preferable. Like I said, some of these things are obvious. Because you may have to be accessing these documents at a later date, because you're required under some of the statutes, under certain circumstances, some of the documents you have to keep for 5 years. It would be nice if you could have an orderly processing system so that they would be easy to find, easy to locate, easy to search for those that need to be searching them. These are things to be thinking about if you're going to keep an electronic. Well, actually, this is a good practice to have, whether you have hard copies of these documents or electronic copies of these documents. Who can access these on a regular basis? What happens if we need to access documents? HR director is on vacation or is on sick leave or not in the office for whatever reason. In terms of federal law, FMLA, you're probably familiar with the Family Medical Leave Act, and the FLSA, the Fair Labor Standards Act, that's the overtime, when you have to pay overtime. They require certain things be documented, that you have to keep records of certain things, and they are the same. So whether it's the FMLA or the FLSA, things you have to keep records of are, again, they seem obvious. Basic payroll information. Obviously, in an overtime lawsuit or an unpaid wage claim, you're going to need to document when somebody worked, when they didn't work, whether that's the day, the time, specifics, literally the specifics, the start date, the start time, the end date, the end time. You just got to keep all that information. If you're going to designate somebody that takes FMLA leave, there are a handful of forms that accompany an FMLA an employee on FMLA leave, whether it's the FMLA leave request, the leave approval, the leave denial, the doctor's note that explains or sets out why they need this leave. Again, I keep saying this, but I mean it. OMAG has all these forms, has all the policies that relate to these things, relate to the FMLA. And so if your city or town doesn't have these things, you can log onto the website or you can call us and we'll walk you through the documents that you need to have, that you need to get completed in order to be able to comply with the FMLA. And then if you ever have an FMLA or an FLSA lawsuit, it's essentially, if you can't, it's the burden's on the employee, obviously, to show, well, I had a sickness that qualified under the FMLA as such, or I worked overtime. But once they make that claim, the burden's on the employer to disprove it. So if you cannot disprove, somebody claims, I worked 60 hours and I didn't get paid for the 20 hours overtime. You've got to be able to prove they're wrong. Lots of cases aren't like that. Lots of lawsuits aren't like that. But under the FMLA and the FLSA, the burden's on the employer to show that they properly paid the employee under the FLSA, or that they properly provided leave under the FMLA, provided notice to the employee of their right to the leave, as well as the documents that underlie the need for the FMLA leave. All those things, it's important to remember, the FMLA and the overtime FLSA, you have to prove you were in the right. If you do not have the documents, that's why I mentioned it's strict liability. It's really problematic, whether it's in a lawsuit or whether it's with the Department of Labor and they're doing an investigation. If you, the employer, cannot prove that you did it right, that you crossed every T and dotted every I, you're going to kind of be up a creek. This is all just kind of following up on what I just said. Just any documents that relate to the FMLA or the FLSA, I think y'all probably know these things. I'm sure everybody here probably also has, if they, at the water cooler, in the kitchen, or in the break room, the various employment-related posters that you got to have proof that you had those. That sounds really simple, but it's literally as simple as somebody needs to be in charge of posting them, and whether they keep it's an email diary, a journal, or whatever, keep a little notebook that says, on this date I posted, the FMLA poster that was revised in January of 2013. And then when it's removed and replaced with the updated FMLA poster, you make a note of that. I said at the beginning, document, and it really is true. In every employment lawsuit I had for 25 years, there was always going to be something that wasn't documented. And it's always painful to not be able to prove something. The level of pain varies, whether it's something minor or something significant. But you can just never document too much. In my experience, in my opinion, you can never document too much. If you have a meeting with an employee to discuss something, and it may not even be disciplinary, it may just be to discuss how last week's conference went, or to discuss, literally anything. In my opinion, if you're going to have a meeting with an employee to discuss something other than maybe strategy on how to approach a project, as a supervisor, as a decision maker with regard to that employee, I would be documenting it. I would create a memo to my employee. This date we discussed this, and you suggested these ideas, and I suggested these ideas, and we're going to revisit this issue in 30 days. And keep it. You just cannot over-document. You can really under-document. You cannot over-document.